If your goal is to exclude evidence, the first step that I would recommend you doing is filing a pretrial motion. This is authorized under the rules of civil procedure. And within the motion, you state the grounds that you contend require exclusion of the evidence. You ask the court to rule on this motion pretrial. If the court rules on this motion, you have preserved the error, whether the court rules with you or against you. Many times courts will not rule on such a motion. The court will want to hear the evidence in the midst of trial before making such a ruling. If the judge does not rule on your pretrial motion, in order to preserve error, you must make a timely and specific objection. When you make this objection, make sure that you state each and every ground that you contend calls for the exclusion of this evidence. When you make the grounds, make sure it's specific and that you outline in detail the reasons why this particular legal principle requires the exclusion of the evidence. The next step is make sure you get a ruling from the trial court denying or granting the objection. In the rare event that the trial court refuses to rule or says something such as "move on, counselor," or something like that, you must ask the trial court to give you a ruling on the record in order to preserve error. If for whatever reason the trial court refuses, go ahead and make an objection to the fact that the trial court has refused to make a ruling on the record. You're not going to make a friend of the judge at that point, but you are going to preserve the error for purposes of appeal. If the court agrees with you for some of the grounds, so believes that you are correct for some of the reasons for the exclusion, but thinks that it should be admitted for certain purposes, the trial court may state such on the record. And if that's the case, you need to make sure and ask the trial court to give a limiting instruction to the jury. This will tell the jury that the jury can only consider the evidence for certain reasons and for certain causes of action. You need to make this request for a limiting instruction in order to preserve error as well. There are other things that you should consider when deciding how to exclude evidence. So if you are in doubt or you have further questions, my best advice is to contact your appellate lawyer.